Matthew Chavez.
And sir, you are the mother of Violetta? Or no, wrong name, wrong names. I am flipping names. Hold on, let me get the right names.
The brother.
It's Andre's the kiddo we're talking about.
Yes, sir.
Okay, you're the father of Andre. I apologize.
No, sir, I'm the uncle.
Uncle, okay. And did Andre at any point stop living with you?
Yes, sir. Back in, I think it was January of 2022.
2022?
Yes, sir.
And do you believe Miss Kano should get possession credits for the time period until the kiddo emancipated for that time frame?
How can I? Yes, I think she should. But the thing is, she was owed money to me for it. So that's
Objection, Your Honor. Non-responsive after yes, I think she should.
Sustained. Just answer the question that's asked, Mr.
Yes,
Chavez,
ma'am.
okay?
Yes, ma'am, I understand.
Okay, so just for clear it up, I'm going to ask that again. You do believe she is owed possession credits for the time frame she had the kiddo until the kiddo was 18 and graduated high school?
Correct.
Okay.
That's all I can say.
Your Honor, I pass this witness.
All right. When did Andre graduate high school? Do you know, Mr. Chavez?
I do, Your Honor. It would have been June of 2024.
All right. And was he 17 at that point?
Yes, he turned 18 in July of 2024, I believe, Your Honor.
Okay.
And Miss Kano continued to pay child support. June 2024 is the last date that Miss Kano paid child support.
All right.
All right, guys, buckle up, because this courtroom moment starts with instant confusion that pulls you right in. The judge struggles with names and relationships, and within seconds, we realize this case isn't as straightforward as it seemed. Matthew Chavez is not the father, not the mother, but the uncle, and that clarification alone sets the tone. You can feel the tension as the court tries to establish basic facts. This intro matters because it shows how messy the situation already is. When identities are unclear, outcomes can get complicated fast. From the very first seconds, you know this case is heading somewhere serious, and every word is about to matter.
So she paid the support during the months she had the kid?
She did, Your Honor.
Okay.
Well, it was taken from her paycheck by the Attorney General.
Okay. Well, there was a court order that hadn't been changed at that point, correct?
That is correct, Your Honor.
Okay. All right. Ms. Eveles, do you have any questions you want to ask Mr. Chavez?
Yes, Mr. Chavez, back in 2023, do you remember in either 2022 or 2023, a process server trying to get a hold of you numerous times?
No, ma'am.
You remember making yourself unavailable to be served with a suit to modify this order?
No, ma'am. I was never aware. I'm very easy to get a hold of.
Okay. Did you knowingly take child support when the child was not with you?
We submitted the paperwork that it was on the Ken Paxton website.
Objection, Your Honor, to non-responsive.
Sustained. Try to just answer the specific question asked.
Yes, ma'am.
Did you knowingly take child support from Miss Kano when the child was not with you?
Yes, but it was appointed by the court.
Objection, Your Honor, to non-responsive after yes.
Sustained.
Did you ever do anything to return that money to Miss Kano?
No, I don't talk to her.
Okay. Do you understand that what you're looking at is about $16,000 that you took in without having a child in your possession?
I'm pretty aware, but like I said, I was never, it was court ordered.
Objection, Your Honor, to non-responsive after I'm pretty aware.
Sustained.
Okay. And back in January of 2021, when this child support was ordered, do you recall that child support was ordered in the amount of $900?
Yes, plus back pay of $100.
Objection, Your Honor, to non-responsive after yes.
Alright, guys, now things start getting real. This is where the core issue finally comes into focus. The child stopped living with Chavez back in January 2022, yet child support payments kept flowing. The judge carefully walks through dates, ages, and graduation timelines, locking everyone into the same set of facts. Chavez even agrees that Miss Kono deserves possession credits, which is huge. But the tension builds because nothing was officially changed in court at the time. This segment quietly exposes the legal trap. Doing the right thing without fixing the paperwork can still cost you dearly.
Sustained.
Thank you. Do you recall that at that time, all of Miss Kano's arrearages were ordered at $5,000?
Correct.
Okay. Do you understand that that order took care of anything that was owed to you by Miss Kano as of January 2021?
Correct.
No further questions, Your Honor.
All right. Mr. Hawkins, do you want to ask Ms. Chavez any other questions?
No, Your Honor.
All right. Mr. Chavez, as a someone representing himself, do you want to tell me anything else about the situation before we move on?
Yes, ma'am. It was just, I got thrown into this for the fact that my nephews and niece called me to pick them up because it was multiple cases on top of this.
Your Honor, at this time, I would object to any testimony that goes behind the order of January 2021.
That was asked.
Okay, yeah. I'm going to sustain that, Mr. Chavez, because that is kind of the starting point of where we're at right now.
Yes,
so I understand that you somehow, under various circumstances that aren't relevant at the point, ended up being the conservator of the child. Okay? So what do you want to, is there anything else you want to tell me about the money and what's owed?
No, ma'am.
Okay. All right. All right, Ms. Abelos, any other evidence you want to present? Well, I guess, hang on. Mr. Hawkins, did you want to call anybody else?
I don't need to call Mom's
Very
state
good.
rest, Your Honor. No
Thank
worries.
you. All right. Ms. Abelos?
Your Honor, yes, at this time I would call Miss Kano.
Okay, if I could get y'all to switch out. She's kind of soft-spoken.
And as the court knows, I'm not, so I'm sure you'll be able to hear me.
I'm right there with you, Ms. Abelos. All right, Ms. Kano, if you'll raise your right hand, please. Do you solemnly swear the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You may put your hand down, and please be sure to speak up, because even right there, you're a little faint from my end. Okay?
Yes, ma'am.
Thank you. Ms. Abelos?
Thank you, Your Honor. Ms. Kano, you've heard the testimony. Andre moved back in with you after January of 2022. Is that correct?
Yes.
Okay. And the pay record has been admitted. It shows that you paid $37,038.52. Is that correct?
Yes.
Alright, guys, this is where the pressure explodes. Under direct questioning, Chavez is forced to answer the question everyone cares about. Did he knowingly take child support while the child wasn't with him? His answers spiral, objections fly, and the judge repeatedly shuts him down for dodging. Then comes the number, around $16,000. That's when the room shifts. This isn't a misunderstanding anymore. It's about money taken and never returned. Every sustained objection makes it worse. This part is uncomfortable, tense, and impossible to ignore because accountability is finally on the table.
If you do the math for the 13 months that Andre was with Mr. Chavez and the $5,000 that the court found you in arrears back in January of 2021, would you say that you paid, or you should have paid Mr. Chavez $16,700?
Yes.
Okay. And so the difference there is $20,000. Is that correct?
Yes, that's correct.
If you do the math for the 17 months that Mr. Chavez was paid $900 for child support when he did not have Andre, that's an amount of $15,300. Is that correct?
Yes.
Okay, so you are asking the court to give you the possession credits against any arrearages that the state believes you have. Is that correct?
Yes.
Okay. And you came to hire me around about 2023. Is that correct?
Yes.
And we tried to get Mr. Chavez served. Is that correct?
Yes, we did.
And did you try and have conversations with him when we were trying to find him and get him served?
I tried to reach out to him, but we really don't talk. So that's why I had to hire you.
Okay. And do you recall the situation being that our process server could not find Mr. Chavez? He would not make himself available to be served.
Yes, that's what the paralegal had told me.
Okay. And
Alright, guys, here's the moment where Chavez tries to regain control of the story. Speaking for himself, he explains how he was thrown into the situation and hints at past chaos involving the children. But the judge stops him cold. None of that matters now. The court draws a hard line and narrows the case strictly to money and legal responsibility. You can feel Chavez's options shrinking in real time. This segment shows how quickly sympathy can vanish when the court decides the facts are already settled. From here on out, emotions don't carry weight, only numbers do.
so in addition to the credits that you got for having possession of your child while you were still making payments to Mr. Chavez, are you asking the court to order that Mr. Chavez pay back somewhere between $15,000 and $20,000?
Yes,
Okay. Do you think that that would be fair and just?
absolutely.
Since the time of y'all going to court in January of 2021, did you pay everything that the court ordered you to pay and then some?
Yes.
Your Honor, no further questions.
All right, Mr. Hawkins, any cross-examination?
No, Your Honor.
All right, Mr. Chavez, as an unrepresented party, you have the right to cross-examine the witness. Again, at this point, I don't want you to try to tell me anything new, but if you have any questions, you have the right to ask them. Do you not have any questions?
No, ma'am, I'm done.
Okay, thank you. All right, then, Miss Avalos, what cause number did you file that you filed your modification in? Because it's not showing up on Odyssey.
Alright, guys, this is the heart of Miss Kono's case, and it hits hard. Calm, direct, and backed by math, she lays out exactly how much she paid and how little should have been owed. $37,000 paid. $16,000 justified. The rest? Overpayment. She explains trying to serve Chavez, trying to communicate, and finally being forced to hire legal help. When she asks the court if it's fair to get that money back, her answer is simple and confident. This part transforms the case from legal theory into real-world impact, and the stakes couldn't be clearer.
Your Honor, give me just a second.
It's possible they just didn't scan it, but
if I may have a second, Your Honor, I believe I can find it here. Your Honor, back in April of 2023, we filed into P10-595 1112 CV.
okay, and you've got a file stamp copy of that?
I do, Your Honor.
Okay, they didn't scan it for some reason, which is the danger of these conversions. So thank you for checking on that for me.
Yes, I am.
All right, is there anything else that you wanted to add, or did you want to make a closing statement? You're not required, as you know, in this court.
Yes. Your Honor, well, if I may, yes, a quick closing statement just to say that we understand that it is unusual to ask for a payment back or to get a payment back. But we believe we did everything that we could to stop the payments. They didn't get stopped, and would be only just and right that Mr. Chavez pay back some, at least, of the $15,000 to $20,000 that my client overpaid.
All right, guys, this is the finale, and it's not the ending many expect. The judge carefully explains the law, and despite everything we've heard, the ruling lands against Miss Kono. Because she followed the court order, the money doesn't come back here. Instead, a new arrears judgment is entered, complete with monthly payments and wage withholding. It's a sobering reminder that fairness and legality don't always line up. The judge explains appeal rights, deadlines, and final steps, closing the door on this chapter. The case ends quietly, but the impact lingers long after the gavel metaphorically falls.
Mr. Hawkins, anything else you want to add?
The state's only request is that Ms. Kano be given possession credits for the time frame she had the child. I am calculating them right now. However, I'm not even halfway through and they're going to wipe out arrears.
Don't bother. Mr.
Yes, ma'am.
Chavez, is there anything else that you wanted to say or wanted me to know?
No, ma'am. I just want this over and done with.
Okay, fair enough. Then here's what we're going to do. Court finds I have jurisdiction over the parties and over the subject matter. Unfortunately, first of all, possession credits are affirmative defenses and do require being pled. And the second issue is if she followed the court order, she doesn't get the money back, in my opinion. There is a cause of, at least not under this cause of action, there is a cause of action that now exists under the family code that can be filed if the time hasn't run. Which it probably has not. So I am entering a child support arrears judgment against Ms. Kano of $7,842.96 as of November 30th, 2025, and I order her to continue to make payments on that judgment at $100 a month beginning January 1st, 2026. I authorize wage withholding. All payments must still go through the state disbursement unit. In addition, I order Ms. Kano to pay the court costs in this matter due as billed to Pecos County District Clerk's Office in 30 days. So what happens now is Mr. Hawkins is going to put all this in writing. They'll send it to me. I'll check it, sign it, send it back. He may or may not run it past Ms. Avalos since it's a pretty cut and dry order. But either way, I'll get it and sign it and send it back. And then the AG's office will send Mr. Chavez a copy of that order. Ms. Kano, yours will go to your attorney and then she'll get you a copy. If anybody does not like what I've ruled, you each have the right to ask the district court to rehear any or all of it. It's called a de novo, but it must be filed in 3 business days. That's Wednesday of next week. And if you don't do it just right, you might not get very far with it. So, Mr. Chavez, if you want to do that, then I strongly suggest you at least talk to a private attorney about how to file it. It's not my job to tell anybody to file a de novo. I just had to make sure you knew you had the right to. So again, thank you very much.